All right, we're going to go ahead and get started. I assume that everybody's in the room for the shoplifting bill that Chairman Fleming has to present. Is that right? So I figured. Okay. Chairman Fleming, if you want to, this is the Reeves Subcommittee of Judiciary Non-Civil, and this hearing is called to order. And Chairman Fleming, if you want to tell us about House Bill 890, and I am looking at LC 297835. Is that correct?
Yes, sir.
You on? Try the other one.
Yes, sir. No.
Try again.
Testing.
Try that one.
All right.
Try the other one that's right in front of you.
Testing.
Okay, we're good.
Okay, great.
Is it?
Mr. Chairman, thank you. Would you like me to proceed?
Yes.
Mr. Chairman, I hope, with all sincerity, it is a very simple bill. Our retail association came to me with trying to address what is really a big issue in not only Georgia but many states, and that is the problem of shoplifting. And I didn't know how sophisticated shoplifting had become, and they started to tell me about the organized groups that give people a list of exactly what they want them to steal. They make sure they stay below certain levels so they don't trigger felonies and whatnot. But the other thing that they're doing, and the simple thing that this bill addresses, is that now it has become fashionable, unfortunately, to use that emergency exit that you see at the back of CVS to dash out of when you're doing your shoplifting, rather than just trying to walk out the front door with the alarms and all. Well, of course, as you might imagine, the alarms do go off with the emergency exit, and that causes everybody in the store to have to stop what they're doing and make sure it isn't a real emergency. But they discovered when talking with prosecutors that it's actually not against the law to use that emergency door for that purpose of shoplifting. It obviously is a misdemeanor, depending on how much you steal, maybe a felony to shoplift. But what they want to do is send the signal out there that, hey, okay, you're going to bust out that back emergency room door, make all the alarms go off. We're going to let you know that just like you're smart enough to not steal too much, you are going to buy yourself one more misdemeanor charge if you use that door that was intended to help people leave in case it was a real emergency and cause all that commotion. That's all this bill does, and I'd be happy to try to answer any questions, Mr. Chairman, you and members of the committee may have.
Thank you, Chairman Fleming. Does anybody on the Retail Association or the prosecutors wish to speak on this? Yes, absolutely. Why don't you come up? Come have a seat right here, and that microphone's on.
Thank you, Mr. Chairman, members of the committee. We'd like to thank the big turnout of everyone who came in here to support this bill. This is, as Representative Fleming alluded to, organized retail crime is very real in Georgia. It's very real nationwide. It seems like every time we build a better mousetrap in the legislatures, it seems like they come up with better mice. This is a good bill that will help, a very small change that will help stem some organized retail crime in Georgia. As an example, one of our members had this happen in Georgia at 83 different locations. And that resulted in 65 apprehensions, and the average cost to the loss to the store for each one of those was $775.
Hmm.
So this is a very real thing, and we think it's a very easy fix, and we appreciate y'all's help.
See if I have any questions. I didn't put a sign-up sheet, but is there anybody in the that would like to speak on this? Yes, Mr. Humphrey, yes. Okay. Anybody else wish to speak on House Bill 890? Okay, is there any discussion amongst the committee? I will accept a motion if somebody has one.
A motion. Do you pass?
Okay, is there a second? Okay, all those in favor of the gentleman's bill LC 297835 on the motion to pass, say aye.
Aye.
All opposed, like side. Okay, congratulations. I believe this will be on full committee tomorrow.
Thank you so much, Mr.
So-
Chairman. Do you know what time and where that meeting's going to be by any chance?
1 o'clock in 406.
CLOB.
Yes.
Thank you so much.
Tomorrow. Full committee. Hmm? Okay, that leaves us with House Bill 605. It's a hearing only. Representative Spencer, if you want to come up, and I believe that you have two folks with you. There will not be we've had public comment on this bill already, so we will not be having public comment on this. There is going to be one speaker has been pre-approved, Carrie Silverman. Are you here, Mr. Silverman? Okay, and so in time, we'll have you come up to speak. So Representative Spencer, take a minute and get ready, and then proceed when you are ready. We're working on LC 297900S. Is that the correct version?
That's correct.
Okay. So why don't you walk us through why don't you start by walking us through the difference between where we were last week and now, and anything else that you want to kind of start off with.
Okay, thank you, Mr. Chairman. Am I on? I don't think I
Yeah,
am.
you're on. You may need
All
to.
right, thank you, Mr. Chairman. We're working off of LC 297900S. I'll just go into the differences, try to go into the changes that we made since the last version that you have there. I'll be honest with you, I can't remember the number right off track, but
The previous number was LC 2978228S.
what was it, 728S?
7828S.
Okay, I just make sure I'm following that. Okay, so with the current substitute you have in front of you, nothing has really changed in the first part of this section 2, 15 through 25. If you're looking at 7900, so nothing's really changed there. What we do start to change is between lines 27 down in through lines 40, and so in that part of the bill, that's what we talk about, the discovery rule. Okay, when last subcommittee hearing, if you go back to the first page, you will notice that a plaintiff has to bring their claim before the age of 23 if they were molested under the age of 18. So they have to do that before the age of 23. When we passed the Hidden Predator Act 3 years ago, that was already current law. We kept that in law. We did not change that. But what we did do was put in an or, and that or starts here in this bill at lines 26. And so that's Roman numeral 1 or small Roman numeral 1. Or within, we said 2 years from the date in which the plaintiff knew or had reason to know that such abuse had occurred. And that set the discovery rule going forward. That was after July 1, 2015. And so what we changed, what similar is the 8 years. That didn't change. But what we're trying to do is widen that discovery window to reflect policy that is consistent with the psychopathology of child sexual abuse. That is the reason why we're widening this 2 to 8. What we're trying to do is give survivors of child sexual abuse a chance to come forward and hold those who did this to them responsible. And so that is a reflection in the policy change, and that's why we're trying to do from going from 2 to 8. So what we changed from the previous substitute that you had, we add the words discovered or reasonably should have discovered that physical, emotional, or psychological injury or condition was caused by such abuse. Now, in the previous substitute, we put effects of abuse. Of course, that was very broad. That was an issue that Chairman Reeves brought up, and so I tried to flesh that out to what does the effects of abuse mean. And so I wanted to get more specific, and so that's why we put those words in there. And again, we sort of moved that language from knew or should have reason to know, and we kind of moved it to the end. So we just kind of strike that and moved it to the end of the sentence. And so that's really the change there. Also, when we move down into 33 through 40, then we start to clean up the discovery language a little bit more, and we reference back to paragraph B2A number 2. Again, it's just sort of referencing that you're in the discovery rule when you're talking about this particular part of the bill. And so that's essentially what 27 through 40 does. It sort of clarifies what effects of harm were or is, and we sort of clean up the discovery language going forward. So that's and we reference that specifically in the bill. Also, lines 41 through 43, that is language that was in the previous substitute, but what that, I call this the interval. That's what I like to call it. What I tried to do here is I want to increase that age from 23 to 38, okay? So what I do, I want to raise that age limit to 38, again, reflecting the realities in policy on child sexual abuse and how this sort of comes disclosed. And so the average age of disclosure on child sexual abuse, the research will, if you look at all of it together, you're going to get a roundabout number around 42. So again, that's the reason why I sort of chose 38, is to sort of try to get close to that. In previous efforts in the past, I tried to get that age higher, but I was unsuccessful. So what I'm trying to do is get as close as I can possibly can to what the research reflects on this issue. And so in this 23 to 38 interval, right now in current law, if plaintiff brings a case against a perpetrator or a potential entity under the age of 23, they can hold the perpetrator to a simple negligence standard as well as an entity on the preponderance of the evidence. That's up to age 23. What I'm doing here in 41 through 43 is I'm increasing the age, but the preponderance of the evidence on a simple negligence standard still applies to a perpetrator. But what I'm doing, if you go down to 57, and you'll notice in your previous substitute there was a paragraph 4. I sort of struck that paragraph 4 out because we're saying the same thing in paragraph 3. But what I did on lines 57 is sort of weave that into this subsection here, 41 through 43. And what I said is the gross negligent standard will apply to an entity going forward if you're in between the ages of 23 and 38.
So if you're under 23 and it's an entity, it's negligence, right?
Simple negligence.
But then 23, whatever,
I'm upping
as
it
your
to
bill is 38,
Mhm.
then it's gross negligence.
Right. If you read paragraph 3, you will see there that it's starting at line 61. By preponderance of the evidence, there's a finding of gross negligence. That applies to the entity, that the entity knew or should have known.
And that's current law.
That is
The only
current
thing
law.
that is just shoring it up to account for the age
The
extension.
interval, right. I call it the
Sure.
23 to 38 interval is what I like. sort of
Ed, do you have
call
a
it.
question now or for later? Okay. Keep going,
And
Jason.
so that's the explanation of that language. Now we get into what I call the revival window, and that's section 3. So, hearing that a little confusing to track the window language in the last substitute, I kind of asked Ledge Counsel to pull that out and put it in a separate section so we can deal with that. And so essentially it's the same language starting at the first part of the paragraph, starting at line 66, but where the differentiation in terms of negligence application applies starts at A and B. So 75 is paragraph A, we're talking about the perpetrator, and that is simple negligence.
So in this case, the perpetrator, just so that everybody's clear, the perpetrator is the actual person whose actions were abusive.
Correct.
Okay.
So that the perpetrator would be held to that standard. That we basically took that language from the revival window we had 2 years ago. We essentially carried that language forward when we reestablished this window, and this window is actually 1 year, not 2, as in the previous law. And so we're going for 2. But what we're doing now is including an entity who had knowledge of such abuse, and they kind of turned away. They looked a blind eye. They had knowledge, and they did nothing. They did not act. They did not report to authorities. And so as a result of those actions, we are looking to hold them to a gross negligence standard, which is already the policy in state law, is to hold them to a gross negligence standard by the preponderance of evidence, but they have to meet certain criteria. And that's where we start on lines 81. And so I want to go back to line 80. So when you start to read 78 through 80, it will tell you where the preponderance of evidence applies to the entity with the gross negligence standard and the finder of fact determines. And so they have to find these facts in order to apply that negligence standard. So number 1 is a person who was a volunteer or employee of such entity that owed a duty of care to the plaintiff, or that the person and the plaintiff were engaged in some activity over which such an entity can control. So there's two parts to part one. So one or the other, but they still have to meet number one and satisfy that to apply. And they have to also go make sure number two is satisfied, which is the entity knew or should have known that the alleged conduct gave rise to this action and failed to take remedial action. That's part one of two. And then also part two of two, which would be or had the responsibility for the care of the plaintiff or legal duty to report, which gave rise to the action. And I will say again, there's actually a third part there, and failed to report it. And then you get to number three. So there's actually two parts. You have to pick one or the other in part two with the failure to report before you even get to number three. And with number three, the entity has to have to receive credible reports of complaints about the person, and that entity has to demonstrate or has to be proven that they do not prevent such person from having contact with the individual who is under the 18 years of age. In addition to those three elements, you also have to, we're requiring the plaintiff to put in a medical or an expert affidavit, if you will, which has to be sealed. We are taking this language from the medical malpractice law. We're not reinventing the wheel here on this. So we're taking that language, and that language is almost verbatim from the medical malpractice tort situation there, and it ends on lines 136. Okay, and so that's the description of the affidavit and what the process they have to go through, and can complaints get thrown out if they don't follow the affidavit process. So we create that process there for the plaintiff. So in recap, what we've done here, in order to include an entity on a gross negligence standard, the plaintiff he or she has to bring that burden to the court, and they have to satisfy those elements, and has to have an affidavit. When we get to lines 137, these are the exclusions where this paragraph will not apply. So any case that has already been settled on the final merits, and it also starts, the window will be expiring in July 1, 2019. Moving into section 4, with offline discussions and what we're seeing, you may have seen a article in the AJC this past Sunday. There was a prominent article on the front page that talked about a coach that was finally arrested. It was a Georgia coach, but the Pennsylvania evidence pretty much nailed this guy and put him in jail. But when you read through that article, one of the main issues there is that people who knew failed to report. They failed to report under the mandated reporter's law. And that is a misdemeanor crime under Georgia law. And so what I'm doing in section 4 is, if those people had a responsibility to do this, they could have solved the problem to begin with, and this guy could have been caught way early if people had done the right thing and not turned a blind eye. And so what I'm doing in section 4 is making a right of civil action if you fail to report and you knew. And that's what I'm doing in section 4. And so that's the bill.
Let me ask you on that, not having the context of 19-7-5 in its entirety in front of us right now. What groups or persons are currently required for mandatory reporting?
There are several groups. I have. If you know off the top of your head, please go ahead. I'll look for it, but I do have it here somewhere.
It's mostly groups who are licensed under this state, so professional, medical, dental, psychological, licensed social workers, and then you're also going to have entities that are directly caring for children, such as daycare facilities, schools, which includes private and public schools. You're also going to have organizations, again, that directly supervise children, so it would include sports leagues and things like that are licensed under this state to engage in those activities.
Mr. Chairman, I didn't introduce the...
Yeah, please, let's do that.
This is Emma Hetherington. She's the Executive Director and Professor of Law at the University of Georgia for the
What was the last name again?
Hetherington?
Hetherington.
I believe you just
That's
received
a
a
lot
copy of my
syllables.
report.
Hetherington, okay.
And
So you're a UGA Law
Faculty, yes.
faculty, yes. Okay, great.
we have it. I've found it. We
Okay.
have it, yeah.
I think And who else is here?
I'm Natalie Woodward, and I'm a plaintiff's lawyer. Got at the moment 5 cases dealing with child sexual abuse in civil context.
Mm-hmm.
And so I just wanted to make sure we knew who we were talking to.
Let-
so.
This is a little off from your bill, but what groups that have consistent oversight of youthful bodies of people or whatever are not in the current list of licensed professionals who are required by law to report? For example, churches, things like that. Tell me about organizations that do not have that mandatory requirement, because there's a whole lot of considerations that we're looking at, and one of the things that I think warrants discussion is, I think we're to the point where any entity that oversees youth should have that mandatory requirement. So tell me what kind of examples of aren't required by law to report.
Are or not?
Are not.
Are not. I mean, most honestly are covered under this. There are some exemptions, such as the clergy privilege, which honestly, under a lot of case law, both on the federal and state level, is narrowing. It would specifically have to be in a counseling session, not just in general. You hear from a parishioner, for example, about the abuse. That would not be covered under the clergy protections. But under the law, child service organization personnel are required to report, and that means persons employed by or volunteering at a business or an organization, whether public, private, for-profit, not-for-profit, or voluntary, that provides care, treatment, education, training, supervision, coaching, counseling, recreational programs, or shelter to children. And it's fairly broad.
Okay, so for example, in your opinion, does a church fit under that?
Yes, absolutely it would. Most churches are not-for-profits.
Mhm.
And then also it is, and they're private organizations that would fit under that as well. And they are voluntarily caring for children.
Do you see, from your perspective, or yours as well, Ms. Woodward, any glaring flaws in this part of our law right now that is someone's escaping that kind of?
I'm happy to speak to that, Chairman. The issue that we're having is that in the context of if someone doesn't report, and let's say they're a daycare worker, and I've had this exact case where a daycare employee sexually abused a 4-year-old little girl. Ultimately, there was no civil cause of action against her employers or her supervisors for not reporting it, even though they knew. And so the most that they could be held accountable was if the prosecutor charged them with a misdemeanor, which they did in this particular case, but there was no civil liability relating to it. So as you can imagine, the practical realities of that with our state prosecutors' offices, they oftentimes will say, hey, okay, this is a person who knew about this, and they didn't technically report it the way they should have, but I've got a caseload that's this wide, and so it's not a priority that they can really have the resources to attend to, which oftentimes is what the civil laws are for, is to pay attention to those issues when the state can only do so much.
Right, and arrests are only made in about 29% of child sex abuse cases. So that's very, very low. And I agree with Natalie Woodward on the fact that there needs to be some sort of civil liability to cover the rest of those predators. Also, I think one thing that our mandatory reporter statute doesn't explicitly cover, and actually is a very interesting legal question that was recently discussed at a conference at at the University of Georgia School of Law, is whether or not the organizations themselves are mandated reporters and what sort of liability, if any, that they would have under the specific mandated reporter statute. What we have seen in a lot of organizations is they have a reporting up requirement. So, for example, if you look at USA Gymnastics, you look at Penn State, they had reporting up requirements within their institutions, not reporting out. So the problem there is, even though some report may have been made up to a higher administrator, No one reported out to law enforcement, to the community. And as a result, that internal decision then, even though there was some sort of report being made, the children that were still under their care continued to be abused and were not being protected.
Representative Spencer, I think I kind of interrupted you as you were wrapping up. Did you have anything else you wanted to add as far as your bill?
That is, in a nutshell, that's the changes that we had since the previous substitute. I would just ask the committee, as you deliberate, I've got a packet in front of you, several documents that addresses any legal questions. I will say, you will see a memo from me addressed to the speaker back from 2014 when I asked him to consider looking at this bill. At the time, before the original Hidden Predator Act was passed into law, that I took that memo, and it's very heavily cited with cases, talks about the constitutionality of the revival window, and also there's a letter from Legislative Counsel that talks about the constitutionality of retroactivity as it pertains to substantive rights or procedural rights as well. So there's a letter there. So we've been dealing with that issue probably for the last 4 years, and it's well documented. You also have two seminal Supreme Court cases that talk about retroactivity on civil claims. 60 pages long in your spare time. Read that. But this is well documented in law and in case law that this is constitutional in terms of revival of claims. So that's pretty much it. As you move through that packet, there's some research from the University of Georgia. She actually, professor here, took the Hidden Predator Act cases and kind of summarized the research, how the law has already been on the books for 3 years now, and what we've learned. And so I think that is a compelling piece of research to look at as you deliberate and debate this issue. I think there's one other document in there. I'm probably forgetting what it is, but those are the important documents there for you to look at. If you have any questions about this, I'll be happy to entertain them. So, but that's pretty much.
We have some questions, and I want y'all up there, and I want to get a dialogue going. Going back to lines 78 through 90, and I honestly can't remember if these were things that we discussed in the last hearing or if these are things that we discussed offline. Obviously, we've had a lot of conversations about this, and it's all running together, but I know that one of the things that we had talked about was establishing some type of prerequisite judicial finding that for a case to proceed, there would have to be a judicial finding that several several elements or findings were met. And the way that I understand that starting in C, the affidavit would have to be something that would have to be coupled with the complaint. But the way I see lines 78 through 90, these would be largely questions of fact that wouldn't be a part of kind of they would be summary judgment type issues and maybe questions of fact for the jury if they survive summary judgment, but it wouldn't be a prerequisite establishment of making a case in order to be able for the door to open to move forward. Is that right?
We're kind of getting to the weeds on this a little bit, but my comment on that would be if we have to establish some type of criminality, we have to, if some kind of criminal act had to be done before we could even move into holding an entity accountable for the actions that they failed to report or something like that, then we have to worry about ex post facto. Then we have to worry about that. But I'll let the experts on that in terms of how that would work in the real world of litigating these cases.
I think that there's two ways I understand your question, which is it possible to create a mechanism where you've got a judicial review standard, right? So you file a lawsuit and a judge has to make a determination of a certain amount of things based on, in the light most favorable to the plaintiff. It's very similar as a motion to dismiss standard. And if the jury, if the judge decides that in the light most favorable to the plaintiff has met these requirements, then the judge can then let the case proceed to full-on litigation, discovery, etc. So I think that is one possible mechanism that would get around any kind of ex post facto issues. It's a possibility. What I think is going to be impossible in a lot of situations is requiring that the perpetrator, have been found to have been criminally held responsible first, because oftentimes the statute of limitations on the criminal cases have already run, and that's not going to happen.
Yeah, and yet.
I understood your
Yeah, I don't.
question
Yeah, and I
on the
don't.
judicial
Yeah.
review process that could be built in, that would then have a judge determining that the plaintiffs had met that hurdle before an entity would be subjected to liability. And I think the answer to that is yes, that absolutely could be that could be accomplished. But I think that it would ultimately be viewed in the light most favorable to the plaintiff anyway, based on the allegations. And so, and that's true already for a motion to dismiss standard anyway. So, and please.
Yeah, and I would also say lines 81 through 90, I think, really do answer the question that you're getting at here. What sort of protections do we have in here that a bunch of frivolous lawsuits aren't going to be filed initially, and then we have to wait sort of 6 months or however long to get to a motion to dismiss? Lawyers are under an obligation not to file frivolous lawsuits. So, and will some be filed? I'm sure some will, but very few, because we are scared of.
I've dealt with several.
Yes.
So.
Yes, but there are sanctions for filing of frivolous lawsuits.
There are, but very rarely does it play out that way. I mean, and you know, I've experienced that, and that's just a
Right.
reality of it.
And as for, I mean, when an attorney is looking at an analysis of whether or not you can file a suit under this provision, lines 81 through 90, you're going through this analysis that quite frankly really does provide a lot of protections against stale lawsuits, against lawsuits where there's not some sort of egregious act or omission on behalf of that entity. I mean, having to owe the child a duty of care. We're not talking about a child that just happens to be playing in the same park at the time that you have this other activity going on. The entity must fail to take any remedial action. That means that when you look at Larry Nassar, there was report after report after report, and no action was taken. That is that failure of remedial action that really is egregious. I think absent these requirements, you're not even get to filing a lawsuit.
Because they would be, the way the process would work is if I filed a lawsuit and I did not have allegations that satisfied all of these elements, then they would, within 30 days, they would file a motion to dismiss.
Sure.
There would be an immediate hearing on that motion to dismiss, and the judge would look at my complaint and say, Natalie, you don't have any allegations on here that they had a duty to care for this child, right? So you're out. You're done.
Sure, and I last year I had a case and I filed a motion to dismiss and actually won. And I know from the case law review, there is a substantial fear. A lot of times those cases end up getting reversed. Those motions to dismiss are reversed. That's a reality of that. A lot of times they are. And I did a lot of research on that, and I won that, but I may get reversed. I don't know. We'll see. But nonetheless, I do think that it's a little bit more complex, because just the reality is that there is an apprehension to dismiss at that level. There's a stronger tendency to let, unless it's just really clearly egregious, to let someone explore their claims. And I think that you would probably agree that's typically how we see cases work. I mean,
Right. I would agree. Lots of times the standard for an emotion to dismiss stage, because it is so early, is that the facts alleged are going to be viewed in the light most favorable to the plaintiff. Right? But there's still going to have to be those facts alleged that meets all of the requirements. They were volunteer. That the conduct gave rise to the civil action was never remediated. There was never any attempt to report. I've got to include line by line by line all those things, or it's not enough to understand. I think from the standpoint of there are different areas in the law where we let judges make findings of fact
Mhm.
in the context of false arrest cases. Oftentimes whether or not qualified immunity applies to an officer. That the judge makes that, what would a reasonable officer have done? That's
Mhm.
a matter of law. That they decide that fact is a matter of law. So there are areas of the law where we extend judges that ability. I think that for purposes of C, with the affidavit requirement, because that has to be filed with the complaint,
Mhm.
I have to have somebody an expert competent,
Mhm.
that to say all of these things,
Mhm.
even if I don't, even if I say everything right in my complaint, but that affidavit
Mhm.
doesn't have an expert who's another doctor, or another psychiatrist or someone stating that under oath and putting their name attached to this complaint, then it would fail even then. So it's a high hurdle for plaintiffs to meet. Obviously, all of those hurdles relate to anyone who was abused before July 1st, 2015.
Mhm.
And that, just to give some context, if someone walks into my office tomorrow and they were abused in 2005 when they were 10 years old, then that meant that they would have turned 22 in 2017. So let's say they go to a therapist, they decide they're going to
Mhm.
finally talk about their abuse. July 1st, 2018, they turn 23.
Mhm.
And the next day they come into my office and I say, I'm so sorry. There's nothing we can do for you.
Mhm.
Because your abuse happened in 2005 when you were 10.
Mhm.
And you came here the day after your 23rd birthday. And there's nothing I can do for you.
Let's board is lighting up. I'm going to start with Chairman Setzler.
Thank you, Mr. Chairman. And I don't know that my questions are going to be dramatically different than other members of the committee. I will walk through the ones I've got. The gentleman's bill raises lots of questions, and I think where we are is, as we go through this, I'd like to get clarity first. And as I look at the line 78 through 90 in the bill, which is the structure that's been created, that's where I think a lot of the discussion is going to be. Before we get there, though, let me look at on lines 75 through 77. I do want to say, we've got this look-back period to the individual. I know there's been a lot of discussion about the entity. I think the entity raises lots of complex questions. But even in the context of the individual themselves, I look at this in terms of fair play. I think we all want fair play. But even in terms of the individual's exposure, if we're going to have a look-back period, which is really indefinite, even individuals have some expectation there being a statute of limitations or the ability to defend oneself and introduce evidence. As you think about it, if there's 10 cases brought against individuals, the plaintiffs get to look at the 10 cases and say, these 4 cases, I think I got the facts to prove. There may be other 6 that might have happened, but you don't have the facts. So the plaintiff gets to kind of pick the ones that make sense for them to win. That doesn't mean that the defendant on the other end of those 4 cases also has the ability to produce evidence to kind of make their claims. So, you might, of those 10 cases, the 4 that are chosen by the plaintiffs, I'm concerned with this look-back period, even for the individual. What if the individual can't produce evidence to get themselves off? Hey, Miss Patsy was the secretary at our organization. She just passed away 2 years ago. If she had only been here, she could tell all, but she's not. She's gone now. So, in the context of getting into court, if you've got a high bar to prove in a criminal setting, the bar really is upon the prosecution to meet that bar. In a civil setting, you might have a relatively low amount of information on both sides, but if it's weighed to the plaintiff's side versus the defendant's side, you're in a circumstance where the defendant may be in a place they can't even defend themselves. So before we even get to entity, which I think is a concern, how clear are we that 75 through 77 provides that fair play? Should there not be an element that says, if it shall be admissible that the defendant can't produce evidence that would be supportive of their case? I mean, is there a circumstance, if we have an unlimited look-back period, that perhaps they should be able to get before the judge and say, Your Honor, but for this person having passed away or not being available to speak, I would actually have a case. I would have an open shut case. But because, again, the plaintiffs got to kind of cherry pick, I was the one they had evidence against. I'm really undefendable. I'm unable to defend myself because my witnesses aren't available.
I'll let the professor handle most of that, but just know that the research that's in your packet there, that provision has been tested. We started that provision 3 years ago, and that's been tested. So I'll let, since she's been the one who's probably litigated half of these cases, I'll let her speak to that.
And to the gentleman, I'm not suggesting that it's not constitutional. I'm not making a constitutional.
I just wanted you to know that we have tested that provision already in Georgia courts.
Well, I'm thankful that the fact patterns in those cases didn't create that didn't create a problem. Hopefully, the people could put up a vigorous defense. There was a vigorous plaintiff side, and it all fleshed out, and fair play led to a good outcome. I'm just concerned, though, as we look at this across the universe of cases, what are we doing even to individuals? Before we even talk about entity, what are we doing to individuals who might not be able to introduce evidence because of time?
Right. Well, first, I do want to mention that when you're looking at these cases, you're looking at plaintiffs who, when they were injured, were children. And so the defendants sort of have a leg up because they were adults. They were the ones who were able to retain documentation and information. They're the ones taking pictures of these children. They're the ones videotaping these children. They're the ones providing graphic literature to these children. Our clinic, as part of our clinic at the University of Georgia, as Representative Spencer mentioned, we have filed 6 lawsuits under the prior look-back provision under the 2015 Hidden Predator Act. To my knowledge, less than 15 were filed in the state of Georgia. That there are less than 30 plaintiffs that are victims of child sex abuse who are able to have any access to the civil law system because of that. If you look at the statistics, we have a little over 10 million people in the state of Georgia. 1 in 10 children will be sexually abused before they're 18. That means we have over 1 million people in our state who have been or will be victims of child sex abuse, and less than 30 individuals actually filed a lawsuit under the last 2-year look-back provision. Here, we're looking at a 1-year look-back provision, and in addition to it, we're saying you have to go out to an expert and you have to get a psychological examination. Those are expensive. Insurance typically does not pay for a proper psychological forensic evaluation, which would be required for this. That is going to decrease the number of people that will even be able to gain access to this look-back provision. You're also going to be looking at if they are able to get into that expert to get that evaluation, a lot of those claims will be found as sort of an unknown, and then they won't be able to file anyways. In terms of the unfairness to defendants, I think that there are some good arguments in terms of, the staleness of the evidence, et cetera, but the plaintiff does have the burden of proving in court by a preponderance of the evidence that this abuse more likely than not occurred. And so I actually think it's a much, as written in this law, I actually think it's a much greater burden on the victims as written than it is on the perpetrators.
And I'll just speak to that briefly. In order for the plaintiff to be successful, we have to pick a jury and have 12 people all unanimously agree that we've met all of these requirements. And so it is a check on our system that if plaintiffs don't believe that, or plaintiffs' lawyers don't believe that you've got enough to go litigate for 2 years, 3 years, 4 years, that you can't convince 12 people to unanimously agree with you that you've met all these, then you're not doing anything fruitful with your time. So as a practical matter, that requirement of unanimous juries, those are the things that are built into our system to keep from frivolous cases happening.
Okay, if this were a circumstance, let's say I was a defense attorney, you were a plaintiff's attorney, and my client wanted to introduce, through the whole discovery process, wanted to get in front of the jury. Jury, these 2 people are the star defense witnesses. Miss Patsy, she passed away in 2012. She was this. She was involved in this capacity in the ministry. God rest her soul, she's passed away. She couldn't be here. Now, if she were here, she would tell you A, B, C, D. She was there that day, as a matter of fact, and she could tell you that such and such. And Mr. Jones over here, brother, he would tell you, would you as a plaintiff's attorney let me get in front of a jury and tell the story that Miss Patsy would tell if she could be there.
Well,
Of-
you are give me an evidence question from law school. So it's the evidence about an unavailable witness in terms of the hearsay exception. And there's actually a hearsay exception if there is an unavailable declarant that Miss Patsy's husband could say what Miss Patsy had told her before she died. I mean, there's even exceptions in the evidence to deal with those situations from an evidence standpoint.
So we, and I'm not trying to win a case here. I'm just trying to probe for what's right. So the question is, do we have enough of a, does the hearsay exception allow us to allow a defendant from something that happened a long time ago to produce meaningful defense using the hearsay or Mrs. Patsy's husband or so and so? Is that a meaningful enough defense to go back and be able to introduce something that happened in 1984 or 1987? I mean, to me, in this balance, that's part of the question here, because it's got to be fair on both sides.
So I think it's important to keep in mind that also that child sex abuse is a crime of secrecy. So if you're talking about an unavailable witness, for example, that unavailable witness is unlikely to have any, quite frankly, good information. In our cases, on the plaintiff side of things, when you look at it, some of the quote unquote witnesses we may have, to the best degree, are going to be witnesses who our client disclosed to show consistent disclosure throughout their lifetime, or a consistent outcry of some kind, or seeing those damages starting to creep up in childhood, etc. But predators are really crafty, and Miss Patsy is not going to have seen the abuse. Miss Patsy might know, you know what, this man was a deacon at my church. I trusted him. He was my neighbor. He's a great guy. But she never saw him touch any child. She never saw him commit any acts of abuse. So, I think in that particular example, it wouldn't actually be very helpful for the defense, and unless you brought in someone to try to say, well, actually, he's not such a bad guy. I think the evidence, so I'm going to give a case example that we have currently under one of the prior open window cases where we are suing an individual, a stepfather. My client did disclose when she was 17. She did go to the police. There was a police investigation. The defendant did admit under oath that he had taken nude photos of my client. He admitted to shaving her pubic hair. He admitted to accidentally exposing his penis to her. All of those things were admitted under oath. That's the evidence that we have. I don't know what evidence he could come up with to the contrary that's now missing. The police file is still there. His under oath testimony is still there. If anything, the only evidence he can come up with is, well, I don't have that camera anymore. And I just, and that's anecdotal at best, but I think that that's more of the realistic type of evidence that we're seeing in these cases.
And Mr. Chairman, I asked the question because that's something that's raised a lot by people who are concerned about organizational or individual exposure is, well, we can't produce a defense, this is an impossible task on our part. So I think we need to probe that to understand, I think you're not convinced it's a really credible claim. It's sort of maybe a diversion, but I think we just need to hear that.
And not every case is boxed up and packaged with an admission under oath either, right? I mean, that's
No, definitely not.
that's a very good scenario, but I think a lot of times these become one person's word against another person's word, which as we know as lawyers is creates a lot of challenges. But I'm going to move to Representative Silcox.
Thank you, Mr. Chairman. Thank you for coming and helping us today. I, first of all, wanted to ask, have there been any cases decided by the Georgia Appellate Courts or the Georgia Supreme Court with respect to the 2015 decision or new statute, the first original Hidden Predator Act?
No, Your Honor. No, Your Honor. No, Representative.
I do that all the time
Not a
too.
judge. Not a judge.
Foreshadowing. There's not been any of those decisions that have reached that level yet.
Okay.
We are still all caught up in the trial courts.
Okay.
As of right now, the trial courts are making contrary rulings that are kind of all over the place right this second in terms of which judge believes can fraud toll the statute of limitations or their issues.
Right.
And it is setting up where it's an inevitability at this point that all of those will be caught up in litigation in the Court of Appeals and the Supreme Court for a long time.
Right.
I believe that one of the issues that the legislature could correct is to short circuit a lot of that. But ultimately, this is going to keep happening. There's going to be a continued litigation on all these, no matter what. We could streamline that process in this bill.
Okay. I guess my concern, and without having the benefit of time to read this lovely set of materials that I was just handed, I know there is, in all seriousness, under the Georgia Constitution, there is a prohibition against bills of attainder, ex post facto law, retroactive law, or laws impairing the obligation of contract or making irrevocable grant of special privileges or immunities. And I know you said that some of these materials address that question, and I was just curious if you could give us some other examples of that in other jurisdictions.
Yes, absolutely. So if you, I believe you were all given a long version of remarks that I know you don't want to suffer through the entire thing orally, but on page 7, I believe that is where I start talking about the look back provision, but specifically starting on page 9, I talk a little bit about how I do not believe that this version of House Bill 605 would violate substantive or procedural due process. So to succeed on a substantive due process claim, the challenge must involve a fundamental right or a suspect class. Otherwise, it's evaluated under a lenient rational basis test. Now, alleged perpetrators of child sexual abuse are not a suspect class under law. There is no vested right in a statute of limitations. So when we are looking, for example, on these procedural retroactive look-back laws, what you're looking at are laws that apply to criminal and substantive effects. You're not looking at a civil law that's procedural in nature. So here what this is doing, this is specifically to, 1, civil claims, and then 2, to a statute of limitations, which is procedural in nature, not substantive. And therefore, under federal law, state law, and I can't speak to other state constitutions. I can only speak to the Georgia Constitution. This bill would be found constitutional. I also do a brief discussion in my remarks on how it also does not violate equal protection. Same argument there, being that because we don't have a suspect class here, you're looking at it under a rational basis. And the state does have a substantial interest in identifying child predators and mending the harm caused to victims, which is a rational legislative purpose.
But isn't it true still that Ms. Woodward testified that these cases are still all over the place right now? There are other cases on the other side of this.
Well, in terms of this issue that you're bringing up, there is no issue on that. All of the cases have concluded uniformly that this is no issue. I've got one specifically where the law, even as it going back as far as the 1800s, is such that because you're not changing anything that's going to allow someone to be arrested
Right.
and criminalized, that in Georgia the statute of limitations in the context of a civil matter is a procedural change,
Not substantive.
not substantive. And because basically we can't go put these folks back in jail
Right.
now. I mean, if we were here talking about opening up the criminal statute of limitations, which frankly I think a lot of us in this room would love that, you couldn't do that because of this ex post facto. So there is no way to now, even no matter how much proof there is that this person was a child sexual predator, if the statute of limitations is gone on the criminal aspect of it, there's nothing to do about it.
What, in
And,
your mind?
I'm sorry, one
Yeah,
more
go
follow-up
ahead.
question, and that is, if there was a conspiracy, and you could prove a conspiracy, you could prove fraud, couldn't, though, a group of individuals, a group of predators, be considered a suspect class? I mean, could they?
Well, and Emma can probably speak to this better. Suspect class in terms of folks that if you are passing a law that has a specification as to men or women or a particular race or a particular gender that is specific to them, that is what they're looking at there and trying to prevent cases that say, oh, this would only apply to men over the age of 65. right, or something in that context, but.
Right, SSI classes refers to race, ethnicity. Gender.
Only those things.
Right, exactly.
I guess I'm thinking in terms of a class action.
Right.
Thank you.
Let me ask it.
I wanted to address
Okay.
a point on the retroactivity. Our retroactive law has been tested in the courts and it has been analyzed. You have a ruling, an order there, so I just would encourage you to look at that. That really goes through an in-depth analysis of that, and I think addresses a lot of those issues.
You know, trying to think before I speak here. Our primary, I think it's safe to say, and I think I can speak for everyone on the committee, our primary objective with everything that we consider is we don't want the guys across the street, the guys and gals across the street, in the higher courts to strike down what we do here. We want to make sure that we're on firm ground and that we do it right. And I think that all the judiciary committees in the General Assembly sometimes take heat for that, because we have to make some very difficult decisions at times. And I guess one of the things that I'm concerned about, and I want to hear, I know, there's another gentleman that's going to speak to us, and I want him to address it, and I also want to hear from y'all. But as we talk about procedural versus substantive due process, and as we look at this kind of unlimited window of going back, do you feel like the further back we get in time that we do kind of wade into more of a substantive due process issue that could very easily create the type of issue that the courts across the street could have issue with? And maybe I'm going down the wrong pathway on this, but without, with a look back that has no boundaries, I just feel like we're crossing over into something that is more substantive, and so help me on that.
I will tell you that has not been an issue that has been what any of the defense has been focusing on. I mean, I think that it is a unquestioned, non-disputed finding across the board that the legislature has the ability to change the procedural rules relating to civil cases, and the statute of limitations is that. Now, as a practical matter, what we're talking about here is a window, 1 year, 365 days, that they would have the ability to file something, no matter when it happened. But I will tell you, just as a practical matter, what that means is that really means things that happened in the 70s, maybe the 60s, 70s, and forward. We're not looking at, no one's here having a case and something that happened in the 1920s specifically. Now, the pattern of conduct, the conspiracy over some of the institutions, that goes back sometimes decades.
Yeah, I understand. Of the potential plaintiffs that have been identified, I see what you're saying. All right, more on that. I'm gonna go to Gravely.
Thank you, Mr. Chairman. And forgive me if I missed this during the testimony. I was trying to read some different areas of the code. I'm trying to figure out, is there a in any other civil cause of action throughout our entire code, is there a set of heightened evidentiary requirements for any other civil cause of action as laid out in this particular bill?
Well, medical malpractice actions, obviously, anything under as Representative Spencer discussed, this whole entire affidavit provision deals with 911 9.1, which has a heightened standard. You actually have to have an affidavit with your lawsuit versus a car wreck case where you don't. Likewise, issues, this is similar, cases where you file a lawsuit relating to something that happened in the emergency department relating to care. There's a heightened standard in terms of you have to prove gross negligence.
Mm-hmm.
So we have identified certain areas in the law where we say, you know what, we want to make it a little bit harder, and there's a state interest to make it a little bit harder than just a normal lawsuit. And those are the ones that come to my mind, and I probably can think of maybe more.
Well, yeah, and I think I agree with everything Natalie just said, and I think that in terms of these specific lawsuits, I would say that it's probably a good thing in terms of the retroactive window to, in certain circumstances, especially as to entities, to have that heightened standard. I think that helps with a lot of the concern over the fact that some of these cases are very old, and will help to sort of limit what can actually be filed. And then also the requirement of that affidavit is also going to help with that limitation, and sort of address some of the concerns against some of the older lawsuits. And then just briefly back to the previous question, I also agree with Natalie on that, and that really what a lot of the case law says about that ex post facto laws and whether they're procedural or substantive, a lot of these retroactive laws that are brought up in the case law have limited time periods, just like the one here in House Bill 605, which is that 1 year time period under which these lawsuits can even come forward.
Did you,
Thank you.
Representative Kendrick?
Thank you, Mr. Chair. So what I'm trying to do is get back to the fundamental question of why you thought it was important to bring this. It's my understanding that there has been, when these egregious crimes happen, it's taken a while for victims to come forward. But is there any particular incident or statistical information that sparked filing this bill right now?
I think that as the cases, as the window opened, and it created an opportunity for lawyers to start looking at these cases, we didn't know what we would find. And so what we have found, and oftentimes, is that the perpetrator was known to the entity, whether that be gymnastics department, UST, United States Tennis Association, and in order to protect the reputation of the organization, they purposely looked the other way. And so that person was then allowed to stay in the organization in some capacity, and the abuse then continued on and on and on and on. And so as we're looking at the cases, we're realizing, golly, if anybody would have just done the right thing here, at this point in time, all of these other children would have not been abused, because he was a known child sexual predator, and there was this idea of insulating the organization in ways that are documented. So I think that has, on behalf of our clients, that anger over this could have been so easily prevented. I mean, if, when good men do nothing, kind of feeling of it was completely avoidable for thousands of children, depending on which organization situation you look at.
Right. And I think there's been a lot of attention recently on organizations. USA Gymnastics is the first one that comes to my mind right now, where they did know. They absolutely knew about these predators within their organizations, and they turned away and they did nothing about it, and then more children were abused. And as I mentioned before, arrests are only made in 29% of child sex abuse cases. That statistic does not include convictions. That's just arrests. And as you guys know, a lot of people who are arrested are not actually convicted. There is a higher conviction rate for child sex abuse crimes once there is an arrest made, but there's still a gap there. And again, only 29% of child sex abuse cases result in arrest. So that means that about 2/3 of child sex abuse predators are never arrested, and let alone convicted. They're not on a registry. They're not known to our communities. They continue to have access to our children. And allowing for these civil lawsuits in absence of that criminal prosecution really does allow our communities, your constituents, to know who these predators are and to protect their children. And on page 11 in the remarks that I provided to you, I also mentioned that it's fiscally responsible. This saves your constituents money. Child sex abuse, and you can see earlier on pages 2 and 3 also of my remarks, I mentioned several studies, one in particular from the Centers for Disease Control, that mentions all of the repercussions that come out through a lifetime for a child sex abuse survivor, whether it be alcoholism, depression, suicide, early initiation of smoking, increased sexual activity, risk for sexual violence, poor academic achievement, financial stress. It goes on and on and on. There's a study that was published under the Child Abuse and Neglect Journal that estimated that the average lifetime cost per victim of non-fatal child maltreatment is around $210,000 in dollars as of 2010. And that's going to include healthcare costs, adult medical costs, productivity losses, child welfare costs, criminal justice system costs, and special education costs. These are things that are not always covered by insurance. They will be covered by your constituents, the people of Georgia. So I would argue that this is also very fiscally responsible to allow for these civil lawsuits, to allow the perpetrators and the entities that knew, absolutely knew, and turned a blind eye to it, to have them pay for the costs and not your constituents.
And I wanted to add to address Representative Kendrick's remarks. We 3 years ago, when we put this forward, and we asked for the entity to be placed in the revival window, and we lost that fight. But what I told committee members was, if we don't do this, if we don't add in the entities who knowingly did these egregious acts, then we have opened that door up by exposing the perpetrator, which was a good thing. But now we have an unmet need, and we have an injustice in these cases that are just sitting there. And how can we ignore that as a General Assembly? We have a responsibility. And I would just say, and remember, when a child is sexually abused, that is the murdering of that person's soul. And they never get over it. They can go through therapy, they can go through counseling, but they never are the same person. That sweet child turns into an adult that gets addicted, that can't hold on to a marriage, that has relationship problems. There is a toll on society. And so I would just ask this committee, think about that. We can get bogged down into the weeds on procedure, on substantive rights, procedural rights, constitutionality. But bottom line is this. The bottom line is this. We have a responsibility to this issue. I know there are other cases out there right now in Savannah, Georgia, and Effingham County that we could help, really help people with this bill if we do the right thing.
Chairman Setzler.
Thank you. To my friend who's nearly a seatmate on the floor, that's why we're having the conversation. The reason we're putting this proposition in front of this kind of scrutiny is because when this committee, and I think it's to Chairman Reeves and people that have gone before him as chairman and subcommittee chairman, have taken the scrutiny, put bills through scrutiny, something kind of comes out of that on the backside. That's what we're trying to do. So there's going to be a very, hopefully, harsh cross-examination, if you will, of this effort to kind of flesh out what this committee could put out. That's why we're here. We wouldn't be committing as many committee hearings to this if we didn't think it was a worthy subject matter. I think about this, and I think, I was looking back in the code, the focusing on the entity. Let me ask one quick question that's more procedural, and then there's Mr. Chairman, I want to be sensitive to time. To your attorney, would you concede that under your framework you've got here in lines 78 through 90, if an entity does not have a legal duty to report, there would be no action that the entity would be subject to? Do you agree that a duty to report through a mandatory reporting statute is an essential element in a duty here, or is that not true?
So
For the entity to be on the hook.
I believe that you would be speaking to lines 84 specifically.
I'm actually looking at line 86.
Okay.
There's a whole series of elements. It's a lot of ands in here, and the ands create a higher burden for you with every and.
Right.
But the legal duty to report on line 86, I see that as a linchpin in this. Am I wrong about that?
So the issue there, I think, is that it failed to take remedial action or had the responsibility for the care of the child. a legal duty to report the alleged conduct given rise to this and failed to report it. So I think there's an alternative there of failed to take remedial action versus a failure to report, as I read it. And I think the idea behind that is that there's quite possible that someone who is caring for a child in some context may not be included in that list under the mandatory reporter law. And so there's scenarios, I believe, where someone who has a legal duty, they know of the conduct giving rise, they fail to take remedial action, or, that's the or there, they had a responsibility for the plaintiff, a legal duty to report it, and they failed to report it.
Okay.
That's how I read it, but
That's where when council puts a comment in there, everything changes. I'm trying to wrestle with that. So or on 85 really becomes the hinge of this entire thing. And I ask that because if it's an essential element to have a duty to report, then what we're saying is we could look at the mandatory reporting responsibilities organization by organization and say, if pastors didn't come in until 2012, then a pastor's, and this organization came in 91, this organization came in 92 or 82, then we could say with some certainty, this organization has no exposure before this date if a mandatory reporting element is essential in this. I just, in reading this, I wasn't sure if it hinged on the or of these ands. So to me, I think if
I think the issue with that is that to the extent that there is a legal duty versus the legal duty to report and mandatory reporter laws, I think it first came about in 80, but it evolved over the years, and when it evolves, it adds more people, just to be more specific, but the legal duty to report, absolutely, I don't believe should be the decision as to whether or not children who were abused and an organization knew they were being abused and they were a child organization and it happened for 50 years. No, I don't think that just because there wasn't a mandatory reporter law on the books that somehow absolves them of their civil responsibility. The mandatory reporter law made it a crime. That's what it did.
In 1970.
I understand, but I mean, the point is, to me, this whole thing hinges, the structure you're building here through 81 through 90, the structure all hinges to me, maybe I'm missing something on the or, that in essence there's a reporting channel you can follow that keeps you within the law, or there's a take remedial action channel that could keep you
either one.
But it'd be either or.
Right.
So to me, what this thing hinges on, this remedial action. What's an appropriate remedial action? And from an entity standpoint, reporting versus it hinges on that. And that is something that to me could be very. It does provide exposure to entities. It did my remedial action.
Whatever it was.
Counseling to this doctor. Hey, you need to not be alone. Let's say this USA Olympics thing. Hey, we don't want you to be alone with these people off campus. Oh, maybe only on campus it's appropriate, or hey, we want you to follow this set of protocols within the Boy Scouts. Is some remedial action, is that going to get the entity off, or is it still going to be because of there was a subsequent crime and set of circumstances that where there was abuse? This remedial action will not get you off as a reporting. So I just say that, Mr. Chairman, parenthetically, there seems to be a lot of looseness in there in terms of organizational exposure, because what is an adequate remedial action? And I think it's with that I get back to the point I was going to make was 9-3-96. It's where fraud tolls the statute of limitations. In my amateur look at this, that statute goes back to 1933. This General Assembly has not touched that since 1933. So that has been in law for 84 years and counting. So, I mean, there's something that's stood the test of time, this idea that you can get around a statute of limitations. And these five fraud elements that you probably know in the definition of the tort of fraud, I mean, it's pretty high. It's a pretty, with every element, it narrows and narrows down more and more. I say that Mr. Chairman, because I don't know that fraud, these 5 elements of fraud are relevant in these cases, because as this operates, this fraud tort really talks about there being a justifiable reliance, this idea that information was positively conveyed and then acted upon in a way that was, that this whole chain of deception carries out to consequences. But the principle there, to me, of there's almost a criminality to it, a calculated criminality that in the civil setting plays out in a fraud scheme, has stood 85 years of test of time. And I guess to me, as I think about this, is there something that's analogous to that? Maybe it's a conspiracy, a conspiratorial set of elements like that, that you could say, if you could demonstrate this, it would have the same weight, the same level of malfeasance as a fraud action. To me, Mr. Chairman, I might be more comfortable if we had that kind of level of malfeasance that could be demonstrated with a very clear and somewhat narrow, but different and distinct than fraud, that could lead to this. I just don't know that, quote, failing to take remedial action, that seems so loose and so wild that it's out of step with what we've been doing for 80 years.
So I would argue that we already have that fraud statute on the books, right? So if someone wanted to file a complaint with a tolling of statute of limitations based on fraud, or if they wanted to bring in RICO or whatever it may be under sort of that fraud conspiracy umbrella, we already have a statute that addresses that. I don't think that we need another one to address that. I think that we can just look to that particular statute.
But I don't think conspiracy tolls your statute of limitations, though.
Well, it can. It can.
Okay.
But so what I would say to your question of what is an appropriate remedial action, I actually think that's a really great question. And when I was reading the bill, that was something that I was asking myself as well. What is an appropriate remedial action?
Mr. Chairman, with all due respect, I said that as a sort of parenthetical remark. I see looseness there. I'd really want to focus on the idea of something along the lines of fraud that could toll a statute. Because I mean, if it's been the law of Georgia for 84 years that something like this multi-tiered fraud schemes is necessary to toll a statute of limitations, if we were to recognize that fraud is maybe different and insufficient to address the equally wrong set of actions, but something that has the same level of malfeasance, criminality to it, if we were to mirror that with something that's analogous, maybe even more serious, what would that look like? I don't know that. I think to me, there would need to be something of that order of malfeasance, if you will, that we would need to demonstrate. So, and I don't want to take your committee.
The gross negligence, real briefly, I think that what we're finding is a conspiracy of silence, in a lot of times, and so why fraud is not just this parachute that we can grab.
I get fraud doesn't work.
Yeah, you don't know what you don't know, so you can't detrimentally rely on what you don't know.
So is there a parallel structure like fraud? Recognizing fraud doesn't work because of its essence. It's something like that.
I think that's what the gross negligence, the point of that was to make that so high that we would have to show something so egregious. I mean, gross negligence is defined under 51.14, and it's the lack of even slight, right? Even a man of common sense would know this is egregious to not act in this situation. And gross negligence is there to cover all of those things, that it's got to be something bad.
And I think we are trying to get to that potential situation in a civil complaint, but this is concealment. I mean, concealment is not fraud.
No,
but it is.
I completely agree.
I think that is as close as we can get to what you're sort of proposing or sort of putting out there.
I think that
is concealment.
I think that what he's saying is that instead of a look back, a new type concept analogous to how fraud tolls a statute, something analogous that tolls the statute as well. Am I right?
Well, speak in plain terms, this ain't as rigorous as demonstrating fraud. I recognize fraud ain't it, because fraud's nature is a whole chain of deceit. because it's silence, because it's conspiracy, because it's different. I think it needs to be different than fraud. This is simply failing some basic duty. This is a negligence kind of thing. To me, fraud is an enterprise that is orchestrated. I think something like that is conspiratorial in nature, that is cover-up in nature. That kind of thing, to me, rises to the level of what you would call criminality that could toll the statute, like fraud does. But is there something that's like this chain of negligence is not like fraud. This is way weaker in terms of protections.
What you're asking, and I think that you make an excellent point, is that to the extent that the allegations would have to be that the entity made affirmative actions to conceal, that the entity affirmatively acted to conceal,
Yes.
that would, if you could show evidence that the organization did that they affirmatively took steps to keep it hidden, and that could include not reporting if you had obligations to report. I mean,
You could introduce that as evidence to try to prove this concealment, absolutely. But as a member of the public looking at this from the outside in, I would say you would need to have a scheme of active criminality for concealment and obscuring and sidestepping the truth and sort of avoiding the truth, talking about not reporting. A number of the things you talk about here could be evidence to prove that, but there would seem to be a series of elements you need to put in place that has that same level of rigor and that shows that malintent, like fraud would. So that's, Mr.
Yeah.
Chairman, I appreciate that.
And we've got to get Mr. Silverman up here you're Mr. Silverman, right? Come on up, and if you just want, and Representative Spencer, I'll give you the last word. But Mr. Silverman, if you want to come up and maybe sit in one of these seats, and thank y'all for being here. I know that y'all are taking a lot of time to come here, and it's very much appreciated. So, Mr. Silverman, if you want to come over here to the microphone and. If you want to just introduce yourself real fast, and tell us what you got to tell us.
Thank you, Mr. Chairman. I appreciate the opportunity to speak with you today. My name is Carrie Silverman. I'm an attorney, a partner at the law firm of Shook, Hardy & Bacon in Washington, D.C. I'm also an adjunct professor at George Washington's Law School. I've studied the civil justice system for many years. I come to you from that oh, there we go. Okay. I come to you from that perspective as a person who has studied the civil justice system and someone who has testified on bills like this in several different states. I'm here today on behalf of the American Tort Reform Association, which is a coalition of businesses, of municipalities, of associations that are concerned with the predictability, fairness, and balance of the civil justice system. And so you may wonder, why is a tort reform group here to testify about this bill today? And it's our concern of the American Tort Reform Association is especially with the retroactivity provision of this bill, of its revival of claims that could be decades old without any other without any significant constraint as to how far that goes back. What I'd like to talk with you today about is why statutes of limitations are really a critical component of the civil justice system for any type of claim, whether it's child sexual abuse, product liability, or anything else. And I can give you some perspective and answer your questions about how other states have addressed this issue, why most have not taken this approach of reviving time-barred claims, and why most have instead prospectively expanded statutes of limitations in these types of hard cases so that we can protect children in the future. And I can also speak to you about how courts around the country have ruled on this type of legislation and why most of them have rejected this type of legislation as unconstitutional. So ATRA's position is generally that every type of claim should have a statute of limitations that is finite, and that any changes to statutes of limitations should be prospective, applying to future claims. I mean, tort law, involves across the board often very horrible injuries. I mean, we talk about serious injuries of people who are maimed by defective products, people who develop cancer or other critical illnesses as a result to a toxic substance. People are hurt and killed by negligence, by recklessness, or even intentional conduct. All of those types of claims, of course, do have a finite statute of limitations. And those, I understand, statutes of limitations often seem arbitrary, they seem unfair, and as applied in individual cases, sometimes they are. But they're in place in all cases because the justice system recognizes that we need to have some bounds on cases to make sure that to protect the courts, to make sure the courts and the justice system are able to decide cases based on the most reliable evidence. To aid them in the search for truth, when we have to make sure that juries and judges are deciding when the memories are fresh, when the witnesses are available, when the records are there, so they can make the best decisions. And it's there also to respect the rights, the due process rights of those who are named in lawsuits, to make sure that they have what they need to be able to defend themselves in courts. And it serves one third purpose, which is, businesses have some reliance interests on statutes of limitations, nonprofit organizations. It may inform their decisions about how long they retain records and how much insurance they buy. So that is this important too. Now, the precise right number for a statute of limitations, as you well know, in dealing with this issue, is a very hard judgment to make. It's a public policy judgment. And what you have in Georgia, as in many other states, is the statute of limitations often varies based on the type of evidence that's involved. For shorter statutes of limitations, you have in cases that rely on memories, on oral statements, on how society evaluates whether someone has acted with the right amount of care, fulfilled their responsibilities. Those typically, as you do here for personal injury and wrongful death cases, 2-year statute of limitation is what applies. In a defamation action, he said, she said, what's true? That's a 1-year statute of limitations. Now, in claims that are based on what one might consider as hard evidence, cases involving a piece of land, a piece of property, you've got longer statutes of limitations because you have that. 4 years for those types of claims, or a written contract, 6 years for those types of claims.
And I don't want to interrupt your presentation, but I want to try to focus what we're doing today and focus your perspective and expertise on this issue to the particular bill. I understand what you're saying in kind of broad application, but what do you see as, I have 2 questions. Number one, what do you see as the constitutional danger of what we're talking about specifically in this piece of legislation? And then number 2, what have you seen in other jurisdictions a tolling mechanism? We understand the tolling mechanism of fraud, and I have no idea what that's like in other states. Haven't had time to look that up, but understanding that what fraud offers in a tolling context may not be applicable to the kind of situations that we're talking about here in Georgia. And have you seen other ways of, other examples in other jurisdictions of different types of tolling mechanisms? I mean, if to whatever degree possible, help us with your perspective on what we are dealing with here specifically.
Well, let me address your second question first, because I think that will be the shorter answer. With respect to fraudulent conduct, fraudulent concealment, that you have that statute as was discussed earlier. And typically that type of tolling applies in cases where there's been some showing of an action taken by the defendant to conceal from the plaintiff what happened, so that the plaintiff would not have learned or understood, known of the injury absent that conduct. So there's typically some sort of affirmative action that applies. So it is there as an exception where court can apply tolling. It is a high standard. It may apply in some of these egregious cases that we've heard about.
And I think
today.
that's what the conclusion we've come to is that there are some fact patterns that would apply to, and then there are some that it wouldn't. And
Right, I would agree with that, Mr. Chairman. On the constitutionality, the law is very clear that the majority rule across the states, of states that have considered this issue, and I can give you case after case after case, have found that reviving claims, once they are barred, are unconstitutional. And they do so based on different reasons. Some of them do so because they have a very clear express provision in their constitution says you just can't do it, period. That's a minority of them. Most of them do so under the due process clause of their state constitution, and they take what's understood as a vested rights approach. And what that means in non-legalese is it applies typically equally to plaintiffs and defendants. So say if you had someone, a personal injury action, a person was injured in a car accident horribly. It takes some time to put a case together. A year and a half maybe has gone by. That person's recovered. They've hired a lawyer. Then suddenly the legislature comes in and says, we've changed our mind. Personal injury cases, you've got 1 year to bring it, and we're going to make that retroactive. Well, you've taken away that plaintiff's claim now, a claim that had accrued. So these states apply that same principle, flip it around for the defendant. If a statute of limitations has run, they have the same rights as a plaintiff has to rely on what the law said it said. And that's the approach that many of these states take. The federal courts have, over time, restricted their retroactivity bar primarily to criminal cases while leaving the door open and expressing concern with retroactivity in the civil context. They've left that door open to retroactivity, and there's a minority of states that have followed that approach and continue to follow that approach as well. In your state, which of course is what you're most concerned about, for a good span of time, the law is very clear that retroactive revivers after a statute of limitation had passed were unconstitutional. In 1984, there was a case that needs to be acknowledged in the workers' compensation context, where the Georgia Supreme Court said, in this type of case, we're going to allow it. It had reversed some prior precedent and allowed it in that context. Very short opinion, not a lot of reasoning, but it took the federal approach. Now, that is going to be something to be reckoned with if this is passed. There will be significant litigation over it, and I think, as you mentioned earlier, Mr. Chairman, the issue is a bit different here. I mean, the legislation we're looking at today, this is not a workers' compensation case where someone developed an injury a couple of years after the statute of limitations had run and the legislature changed it. This, there will be cases on their facts where you've got allegations from 30, 40, 50 years ago where everyone has been, all the witnesses are dead, the evidence is not there for the defendant to present, and that will present a new question for the court, and it will present an opportunity to revisit it, and they very well may look to court decisions from all of your neighboring states that have come to the conclusion that I'm talking about Alabama, Arkansas, Florida, Louisiana, North Carolina, South Carolina, Tennessee, just to name a couple, that have come to the conclusion that reviving these types of claims, not just these types of claims, reviving claims, period, is unconstitutional.
What about, and again, I may be going down the wrong pathway on this. I actually woke up at 3:30 this morning, and I couldn't go back to sleep because I immediately started thinking about this, and my mind started running, and whatever. And trying to understand. I was asking about it earlier, as the understanding the procedural due process, but to me, the farther back in time that we go, it becomes less black and white and more of a gray area where it is substantive in some ways. And do you agree with my premise there? And if you do you think that creates a greater concern for a higher court to strike something like this down? I mean, this is, in fairness, it's the same question that I asked the other lawyers up here. But does that make sense?
Yes, Mr. Chairman, and I agree with.
And I'm not saying that I come up with good ideas at 3:30 in the morning, but
I agree that with that. The Georgia Supreme Court, this is going to present a very different factual scenario than what it considered in 1984. And when this case comes before the court, they're going to have to relook at this issue. And the further back you go, the greater the due process concerns are going to be. So whether the court adheres to what it said in 1984, says let's look to some of the other ways that our sister courts have ruled on this and take a different approach, or make some adjustment to what we said before. I think it becomes more likely as you have a completely open-ended window.
okay. Does anybody on the committee have any questions for Mr. Silverman? Anybody? Okay. Thank you for being here. And then Representative Spencer, if you wanna come back and respond and have the last word. Obviously, this is a hearing only. And I just, as you approach, I want to say, and I want everyone to hear this. This is my 4th year in the legislature. It's my 4th year on the Judiciary Non-Civil Committee, and I think that we probably hear some of the most emotionally driven issues that are taken up in the Capitol. And I mean, I can't think of another committee that deals with legislation where people have been hurt as much as we do, and it is so we deal frequently with some very difficult matters, and I will be perfectly honest and transparent. This has been one of the hardest concepts in my 4 years here, with wrestling with how to figure out what it is that we are to do. This has been, for me, the hardest issue that we've taken up in this committee on how exactly to respond to this, and it's not something that I've taken lightly, and I don't think anybody else on the committee has either. And we're still working, and we are still we're still working on this, and we're still looking at it, and we're figuring out the best way to move forward with the collective wisdom of the committee. But so thank you and everyone for where we are today, and for the discussions that will happen and where we'll be next week. But I do want to give you the last word, Representative Spencer.
Well, thank you. This rigor, this examination of the bill is reminiscent of 3 years ago.
Mm-hmm.
We went through hours of testimony 3 years ago, very much like what you're hearing. But I want to address the issue of the statute of limitations. The statute of limitations, just remember, is a legislative choice. We decide. And the courts have great deference to statutes. They look to the instruction from the General Assembly. I understand the issue of reaching far back into a revival window and maybe stumbling on a substantive right. But what we have now, and what is clear in case law, and what is clear with Supreme Court rulings, and what's clear even in Georgia Supreme Court rulings, and even recently, the Hidden Predator Act's revival window has gone under that scrutiny. And a judge already has relied upon these known case law facts on the statute's limitation. And I just want the committee to know that, is that we didn't reinvent the wheel. We didn't create something new. But if there is the concern about reaching that far back, and maybe diving into a substantive right issue, then we have spoken when we make that legislative choice on the statute of limitations and changing. And we're not, it's not a car wreck case. It's not a slip and fall case. This is child sexual abuse. And what we know about child sexual abuse is that the effects of it are latent. We know they come latent. We need to have a policy set up in place that recognizes this. And over again in states who have reformed their statute of limitations on the civil side of things and criminal, is what we do know is that it is the only tried and true law mechanism in law that can flush out the predators. And here's why I say this. And the reason why I say this is when we make that legislative choice to tell the courts, this is our will as a legislative body, this is what we want to see on this issue of child sexual abuse. What happens is when another victim has the evidence, another one comes forward, another one comes forward, another one comes forward, another one comes forward. That is the pattern you see with the pedophile. The pedophile in their pathological state reoffends over and over their lifetime. And a serial pedophile will offend over 400 times in their lifetime. 400 victims. Grasp that. SOL reform is the only tried and true way to flush these predators out. And if they are still offending and the victims are still older, if they are still older and their time they've been locked out of the courthouse doors. But what if this predator is still offending and the child is under 18? Then you have a criminal case. Then you can put the sucker in jail. That's what we really want to do. And the civil statute limitation reform on an issue like this augments what we did in 2012 by removing the criminal statute limitation in 2012 on this issue of child sexual abuse. So just remember, we're not talking about slip and fall at Walmart. We're not talking about a fender bender. We're talking about child sexual abuse and recognizing that this issue shows up later. It has been proven without a doubt that happens. So remember, SOL reform is a legislative choice, and the courts look to us for that instruction.
So I think Chairman Setzler.
Question is there any examples of, by creating a window for organizational culpability, that organizations could be given sort of an out that, hey, if you've got some culpability looking back, but if you bring forward evidence on some people, is there a way to by creating some organizational culpability, get organizations to flush out and sort of aid in bringing people to justice? I mean, I think we won't settle that here, but my question is.
But what you're finding now is when the Boston Globes broke the story on the Catholic Church, what you're finding now is a culture shift, a psychological shift in the nation's conscience on an issue like this. And then what they're finding now, what you're seeing is organizations internally are saying, we got to have policy and procedures in place internally. We're going to take those corrective actions internally.
I guess what I'm saying is, Mr. Chairman, can we create conditions where organizations, as you create civil exposure for them, don't go to ground, protect themselves, lawyer up and protect themselves? Is there any examples of where we can create circumstances where the organizations themselves can help flush out some of the predators they may have had or actually participate in the effort of helping bring these people to justice? Parenthetical question.
I'll explore that with my experts, but sure.
And the last thing that I would like to say, I agree with a lot of what Chairman Setzler said about the framework that we created here. But I think that, part of the layers of, there's different layers of concern we're looking at. And if we create a 1 year window was created, then that will help some people in some certain circumstances. But when that window closes, there's going to be other people that, that need that, that there's kind of a perpetual chase here. And that's part of the kind of fundamental issues that I think a lot of us are struggling with. But what I would really like to know is, and I don't know the answer to this, is what kind of mechanisms in other states exist that toll statutes that and we can look at that. But to what Chairman Setzer was saying a few minutes ago, something that is similar to how fraud operates, that something to that effect is, to me, maybe a better way to address this.
I hear it. I hear what you're saying. I hear what you're saying. I think what you're, in terms of the civil world, you're looking at the concealment, the known concealment. I think that is as close as you can get to fraud in trying to prove gross negligence. If that is a concept that this committee is wanting to develop, but that's what we're talking about is concealment, because that's really when the damage gets done, is when the person conceals and then the offender continues to offend. It's concealment.
And so again, if there are examples, the first thing that I always do when we're talking about new things is I want to know, what are other states doing on this? And sometimes that's informative. Sometimes there's a good reason not to follow what other states are doing. But that's the first question that I always ask, and that's a discussion that I'd like to have and over the weekend, and as we kind of dig in at the next layer on this. So again, we're going to wrap things up because we've got to move on to the next subcommittee. But thank you for everything that you're doing and your passion on this, and we're going to keep working on it. So
Thank
this
you.
hearing is adjourned, and I believe we're going to roll right into the next.